What I have found is that one of the biggest myths about CEQA is when people think it's an automatic ban on development projects, because it's not. CEQA isn't a stop sign. It's more like a spotlight. It forces the government to think before it acts. So when a project needs a discretionary approval, like a permit or a zoning change, CEQA kicks in and it forces the government to ask questions like, will this project pollute the air or water temporarily or permanently? Will it create traffic problems? Will it disturb endangered species or historic buildings? Will it affect noise, light, wildfire risk, or climate change risk? And if the answer is yes, then CEQA forces another set of questions. Can you fix it? Can you avoid or mitigate the damage? Can you do something else that's good for the environment if you really have to have this project and the public benefit of it outweighs the harm that it may cause? CEQA doesn't block a project just because there's an impact or just because people don't like it. It does require that the government acknowledge the possible harm, explain its reasoning, and have a good justification. That's why it's an environmental review process and not an environmental veto. But here's the twist, because that process can be really long, expensive, and can be the subject of lawsuits that go on for a really long time. And that's where the controversy begins, which is what we're going to cover next.